Okay, so welcome to the second panel of the 2023 Originalism Symposium. This one is titled Originalism and Privacy, What Does the Fourth Amendment Require? So the protections of the Fourth Amendment are triggered only when a government agent commits a search or a seizure. It's therefore immensely important how Fourth Amendment doctrine defines that threshold requirement. In Katz versus United States, the Supreme Court famously abandoned a property-based rationale for defining Fourth Amendment searches in favor of one rooted in reasonable expectations of privacy. For decades, Katz was king, but in recent years, encouraged by majority opinions in cases like United States versus Jones, as well as concurring and dissenting opinions in cases like Carpenter versus United States, some courts have begun to urge a property renaissance. We've assembled a panel of scholars, all of whom participants in that academic debate, to discuss this important issue. Moderating the discussion will be Professor Richard Ray. Richard M. Ray's primary research and teaching interests are in criminal procedure, federal courts, and constitutional law. He joined Virginia's faculty in 2020 after serving on the faculty of the UCLA School of Law. Ray earned an AB in social studies from Harvard University, an MPhil in political thought and intellectual history from the University of Cambridge, and then he received his JD from Yale Law School. After law school, Ray clerked for Judge Brett Kavanaugh of the U.S. Court of Appeals for the D.C. Circuit, and then, in what appears to be a theme for today's panel, for Justice Anthony Kennedy of the Supreme Court of the United States. Ray also worked as an honors program attorney in the criminal appellate section of the U.S. Department of Justice and practiced law at a firm in Washington, D.C. Professor Ray?
Thank you, everyone, for being here. I'm really excited about today's event. So I'll give a brief introduction of our illustrious panelists who have a lot of wisdom and insight to share with us. So first we have Danielle Donfro, an associate professor of law at Washington University School of Law. We also have Professor Danielle Epps, who writes at the intersection of constitutional law and theory, criminal law and procedure, and federal courts, and may also profess at times. We have Professor Orin Kerr, who is a law professor at the University of California, Berkeley School of Law. And we have Professor James Stern of the William and Mary School of Law. So I think what we could do at the beginning is just start off by having each participant make a few remarks about their own view of the Fourth Amendment as applies to this question of searches and seizures, and in particular, whether or not they view their own view, they understand their own view as originalist, as contrasted with alternatives. So Danielle, why don't you kick us off for us?
Great. Well, I'm going to start off and talk about our theory in general, which is a theory that incorporates some property and private law concepts. And then Danielle is going to talk, give an example of how that might work. So in an article that just came out in the Yale Law Journal, Danielle and I lay out a theory that we call the general law approach to the Fourth Amendment. And under our theory, courts in Fourth Amendment cases, in fleshing out the contours of Fourth Amendment rights, should look not to just the kind of reasonable expectations of privacy tests under Katz, and instead they should be looking to concepts of property. This is something that some of the justices on the court currently, at least Justice Gorsuch, is interested in doing, but there's been a lot of uncertainty about what exactly that looks like. Another member of this panel has offered one particular version of that. I don't want to take the wind out of James's sails, but our idea is the following, that courts should be looking to general law. What is general law? General law is the kind of common law of the United States that is common to the whole country, but is not necessarily under the control of any one jurisdiction. They can sort of just be trying to figure out, okay, is this, does this particular interest, is it protected under principles of kind of general common law? Would this be recognized as something in which a person has a right? Could we say the government was violating that right? Danielle can sort of give an example of how that might look. Our theory, I think, is not primarily an originalist theory. We are not originalists. I do think it has a lot to offer to originalists as follows. In terms of the original understanding of the Fourth Amendment, I think it's hard to have a lot of confidence about what it meant. And there's been a lot of historical changes that make it really hard to translate into from, the 1791 until through 2023. Some people think the Fourth Amendment was just meant to forbid so-called general warrants. Some people think it incorporated a broader set of common law rules and so forth. But a lot has changed in that time. And in particular, at the time the Fourth Amendment, came into being, search and seizure protections were largely litigated through state law trespass suits against individual officers. And general warrants and warrants generally were these kind of documents that searching constables could rely on as immunities from tort liability. Today, we treat the Fourth Amendment as actually providing kind of a detailed code regulating the contents of search and seizure law, and it's primarily litigated in criminal, not civil cases through exclusionary rule litigation. So a lot of big changes. Our theory, though, we think provides the best translation from the way things once worked to the way they work now, in the sense that at the sort of original time, before the Fourth Amendment and after, what would happen is you'd go to court, you'd say, hey, someone violated my rights. This search was illegal, and you would go to court, and that would be litigated through tort law. That would be litigated through common law. Courts would be looking at common law principles, and our approach asks courts to engage in that same kind of inquiry. That said, it is not a strictly originalist approach, because to do pure originalism, you might have to dial back a lot of changes. You might have to get rid of statutes that immunize state and federal law enforcement officers from ordinary tort suits. You might have to go back to a world where these things are litigated in civil court. And instead, we think our approach asks courts to ask the same kind of questions that they would have been asking in that original context. And so in terms of translating the original context of the Fourth Amendment today, we think it provides the best, at least the best compromise, while not trying to, in our paper, we don't try to defend it and say, this is the original meaning of the Fourth Amendment. And Danielle is going to talk about how it might work.
So I mean, just to give one example that's near and dear to me is, as we talk in our paper about the idea of bailments, and Justice Gorsuch is raised the specter of bailments when talking about cloud storage in his dissent in Carpenter. And what we're saying here is, like, there is a state law of bailment, because bailment is the law of possession when somebody who's not the owner is in possession of something. There's no like federal hook for the federal government to define what bailments are of like everyday objects. That said, when you're talking about the Fourth Amendment and you're talking about, well, when is it that Fourth Amendment protections would kick in? It's not the case that each state law might govern with the quirks of state law, but we're suggesting that we would look to these common law concepts and deploy a general law function. Now, general law can seem really weird after Erie, but I would urge people to remember there are areas where it is alive and well and has always been, most notably admiralty. And so there are state law definitions of wrongful death and things like that. And then there are general law definitions that get used in context where allowing too much patterning in state law might be disruptive, particularly to the law mercantile. And so one thing that we're arguing in this paper is that we can look to something like a Blackstonian idea of like, what is the law of bailment that would draw on state law as evidence, on just legal learning as evidence. And we're willing to bring in lots of different sources. And we would say, okay, well, if under this idea of bailment, it is the case that everybody could look at this item, then it would be available for searching. But if the bailment is such that the bailee could not break bulk, is the terminology that gets used. That means like literally opening up the goods, undoing the bales of fabric and whatever it might be. Then we would say that breaking bulk is a search, and that would start to entail Fourth Amendment concerns. These kinds of ideas, these rich, or I should say deep common law pockets of doctrine, I think allow us to bring in modern technologies that are where we might have our biggest concerns today. Or I shouldn't say biggest, because what's going on in your home is probably your biggest concern, but significant concerns. And so I've written separately about bailment. in the cloud storage context, arguing that we should redeploy some of these common law ideas to capture new technologies. And so I think that this can help us in understand what Fourth Amendment rights might be, particularly in cases where like your email is held by Gmail. We know when we consent to Gmail, searching through our Gmail. Likewise, students, if you're using Box and Dropbox, those companies are also reading through your documents, albeit not to advertise to you, but they're looking for child pornography. They're looking for copyright violation, often in ways people don't expect, but they're not, there's no bulk that's not being broken there per se. And yet we would still say that's perhaps better thought of as being private, notwithstanding the disclosure to the third party, because outside actors, parties that are not the bailee, are not allowed in. And so we would think of that more like a safety inspection. Are we making sure there's nothing flammable being put in this warehouse? Are we making sure there's no child pornography being put on this server? And so we're viewing this general law as a way to provide tools for understanding modern technology, as well as the tried and true situation of law enforcement wanting to go through a warehouse. And it's not necessarily aimed at being originalist, but to the extent that we think that the common law had a very important role early on in this nation's history, and that's evidenced by all of the very early reception statutes, that might lead us to think that we should bring in more common law type lawmaking, and then maybe restore some of the common law powers to other parties when interpreting other rights. I'll leave it there. I think I'm over time.
Great. Orin, you want to pick it up?
Yeah, I want to say thanks so much for the invitation to be here. It's a great group to see so many familiar faces, even if only from Justice Kennedy's chambers. No, just we have at least one addition. Thank you, Danielle, for coming. So it's great to see everyone. And I'm going to take this in a slightly different direction. I think the premise of the panel was false. Our colleague who started off by saying Katz versus United States famously departed from the originalist. That's just bull. That's just wrong. Katz is completely consistent with the original public meaning of the Fourth Amendment. In fact, if you try to reconstruct an original public meaning of the Fourth Amendment using common law concepts, using case law, cut off your date at 1791, you will just recreate the Katz test using slightly more common law language and citing cases with 1-7 and 1-6 in front of it instead of 2-0, but it doesn't make any difference. It's all the same stuff. And so let me explain why I think the Katz test is completely consistent with originalism. In fact, if you try to just start from scratch, from first principles, you just get back to the Katz test. So here's why. Let's start with the text of the Fourth Amendment. Seems like a good place to start. The right of the people to be secure in their persons, houses, papers, and effects from unreasonable searches and seizures shall not be violated. That's the key phrase that we're interpreting. What did that mean? Where did that come from? Well, it emerged not from whole cloth, from nowhere. It was basically the Madison's, with some slight amending in Congress, a version of similar language that had appeared in state constitutions. The Massachusetts Constitution of 1780 had similar language about unreasonable searches and seizures. The Virginia Bill of Rights had introduced the idea in state constitutions of having prohibitions relating to search and seizure, although originally it was really just phrased as being a ban on general warrants. And in fact, Madison's original draft of the Fourth Amendment in 1789 was really also about general warrants, and then the language gets spliced to sort of have this individual phrase. But this notion of a right to be secure against unreasonable searches and seizures in your persons, houses, papers, and effects would have been understood at the time of the drafting of the Fourth Amendment to really be encapsulating a series of cases and disputes mostly about general warrants that had occurred in England primarily in the 1760s, Wilkes versus Wood, Entech versus Carrington, and then also maybe the writs of assistance cases in Boston in the colonial period. And what was going on in those situations? The king's officials were breaking into people's houses, breaking into people's offices, rifling through their stuff, breaking open their boxes, grabbing potential evidence, grabbing documents, grabbing leaflets, and taking them away. Then lawsuits were brought primarily, although it arose in different remedial contexts. And the question was whether it was lawful for the king's officials to break into the person's house and take away their private stuff. And so what would unreasonable searches and seizures in the right to be secure in persons, houses, papers, and effects from unreasonable search and seizures in ways that then could be searches and seizures that could have been permitted with valid warrants? Well, that was the breaking into physical places. That would have been the mindset. In fact, there's a little bit of debate, not a lot, but a little bit of debate as to the need for a Fourth Amendment in the original Constitution and the debates as to ratifying the original Constitution. People say, well, what if the king's officials break into your house and take away your stuff? There won't be any remedy for that. And so the Fourth Amendment is part of the Bill of Rights in response to that. In other words, this is all about breaking into your home and taking away your stuff. That was what people thought this was about. Now, if you look at the dictionaries that were in use at the time, and let's focus on Samuel Johnson's famous dictionary from 1775. What did search mean? Well, he had a couple different definitions, and here's where things, in the same way we have today, the word search could mean a couple of different things. First, the first definition Samuel Johnson uses is inquiry by looking into every suspected place, and then also examination, and then broadly inquiry, act of seeking, quest, pursuit. Pretty similar range of definitions like we use today for the word search. The challenge here, I think, is that search could mean physically entering into, as were the facts of Entick versus Carrington and Wilkes versus Wood and the like, or it could mean sort of looking at from the outside, but looking very closely. You're searching for the Big Dipper. When you look out into the night sky, you're not actually going out into space, but you're watching, looking closely, or you're scrutinizing something closely. This notion of what counts as a search, is it just physical intrusion or is it more than physical intrusion, is really the puzzle that the Supreme Court is grappling with. Everybody agrees, first principles, no one questions, physical entry into a protected Fourth Amendment space. Physically entering into a home is obviously a search. That is Entick versus Carrington. That is Wilkes versus Wood. The real question is what short of that counts as a search. The reason why that matters so much is that we live in a technological world in which the government has technologies to get private information or things that seem private without physical entry. And that is why the Supreme Court in 1967 decides the Katz case and is trying to figure out what is physical entry required when the government places the microphone on the top of the phone booth. They didn't actually enter a home, but they touched a private thing that Katz had rented, the phone booth, in which he entered and closed the door and put in his coin, and sort of it was his temporarily private space. What does the Fourth Amendment protect beyond sort of physical intrusion into your house? And the reasonable expectation of privacy test is born as a way of identifying, how do you know what is a private space akin to the home in the 18th century, akin to a person's private letters, for example, in the 18th century, that person's effects, that person's papers. What's the modern analogy? And the real challenge is, when does modern technology let the government learn something that is analogous to the physical entry that was the big issue everyone cared about in 1991? One answer would be it covers nothing. This was basically Justice Black's answer in Katz dissenting. All that matters is physical entry. You just got to break in. And anything else is just legislative policy making. Leave that up to state legislatures or Congress. We don't do that. But what the court in Katz was thinking is, well, as technology changes, it makes sense for the Fourth Amendment to capture that technological advance, such that I think Andrew Ferguson put this as sort of future-proofing the Fourth Amendment, so that the rules of the Fourth Amendment aren't completely outdated when the latest technology comes along. What are examples of that? Well, like Kylo versus United States, the thermal imaging device case, where the government can learn what's going on inside the house from outside the house, from the public street. And the footnote in Justice Scalia's opinion in Kylo talks about, what about tools that might allow the government to see through walls? Well, if the government can see through walls, without physically entering through some new technological feat, the Fourth Amendment is eliminated in its importance by technology. And we can't have that. We have to maintain the protection that we had at the time of the founding, at the time of the framing of the Fourth Amendment. And I think that's all that the reasonable expectation of privacy test does. All it's doing is trying to identify what are the modern day equivalents of the breaking into a home privacy invasion that would have been, that was what was animating the enactment of the Fourth Amendment. Why use this phrase, reasonable expectation of privacy? And here's the challenge for you. Try to come up with a phrase that identifies that modern technological equivalent of a physical invasion. What do you say? You say, well, it's kind of like an invasion that's like that a person today might see as equivalent of, that a reasonable person would see as equivalent of, that maybe society is prepared to recognize as reasonable. Whoops, we've just gotten exactly into the Katz test. And so I think that's what the Katz test is doing. The whole society would be prepared to recognize as reasonable language. It's not some sort of free form like judges, what do you feel? Or what is, let's do some empirical study about what people believe. It's just asking, in our modern society, given how we treat certain spaces, what is akin to, what is analogous to these invasions that the Fourth Amendment was enacted to prevent. And so email, very naturally like mail. And so courts have said it violates a reasonable expectation of privacy for the government to access someone's email. Thermal imaging, same thing. It's sort of the virtual entry into the house. It doesn't matter that there's no physical intrusion. I think if you look at the cases, it's very consistent with this notion that all the Katz test is doing is making sure that this 18th century concept is put in a technologically neutral way, so the technology doesn't just completely dramatically eliminate the role of the constitutional protection. You can phrase it as Katz, reasonable expectation of privacy. I think you can phrase it as general law, use common law concepts to sort of reconstitute this, do the same thing, get to the same results. I'm a legal realist. I don't really care what terms are used. I care sort of that it's consistent with the original conception of the Constitution, and that there's a rule that achieves those goals that officers in the modern world can follow. The language doesn't matter so much. And I think really what we're talking about is not so much what is originalist versus non-originalist, was sort of within this zone of shared agreement as to kind of what the Fourth Amendment should be doing, what language is the best language to get there. So I think the Katz test is completely consistent with an originalist understanding of the Fourth Amendment. If you get rid of it and try to reconstruct a new originalist test, you end up sort of doing the same thing as Katz. And I think that's what Justice Gorsuch was getting at in his opinion in Carpenter. The concepts, the principles that he suggests we need to, restore the true original law, those are Katz principles. All those principles are found in the case law under Katz. So I think we're kind of, it's a terminological difference, not really a difference as to what the Fourth Amendment should be doing, which is ultimately what matters.
Terrific. James, are you a realist originalist?
I think that it's a pleasure to be here. Thank you for inviting me, and a pleasure to be with this august company of persons. I have learned more from Professor Kerr about the Fourth Amendment than probably anybody else along the way. I do disagree, I think, somewhat vociferously, and we'll try, and in light of time restrictions, I'm worried if I start, I won't be able to stop. And I'm inclined simply to say I would second the sentiment that I think everybody has expressed to a degree, that the history on the Fourth Amendment sort of historical background is relatively scant in terms of a lot of the kinds of questions that we're faced with today. I don't mean in the sense of, what did James Madison think about email, but more generally, just a whole, even in its own time, even if there had been no technological change, there are lots of questions that would emerge that are the sort of questions we deal with today that are unaddressed, or where the record is ambiguous in various respects. So it's difficult in that respect. And the thing about privacy as an idea, as well as reasonable expectations of privacy, is that I think there's a lot of room for those concepts to mean what one would like them to mean, or what seems just sort of makes sense. So it's easy to sort of project a lot of meaning into it, which isn't there, and it can sort of mask disagreements over more particular and precise questions. The view that I in print have endorsed, and Professor Ray to a degree as well, and both the professors Epps centers to some degree on the positive law background, or the rules of general law that are applicable in ordinary interactions between people. What are the general rules of the road in society? And the specific thesis that I and my co-author Will Bode advanced is that the kind of activity that triggers Fourth Amendment protection is when government officials engage in something that's not otherwise legal for a normal person to do. In other words, they're relying on some kind of exemption from the law because they're the government, in order to take custody of you, take custody of your stuff, or investigate you. In a nutshell, is that an originalist theory? Being a good lawyer, I might perhaps interrogate what is meant by the question exactly. But as I said, the historical record is fairly. There's a lot of room for interpretation in it, but we would argue that this is highly consistent with the record, and perhaps the best reading of what the historical record supports. And let me, if time permits, rattle off 6 approximate reasons for why this might be so. The first just is thematic. What is the Fourth Amendment all about? In the 20th century, we're very accustomed now, particularly as tech becomes more and more invasive, we're very accustomed to the idea of privacy in the sense of an ability to keep information from becoming known, a protection from prying eyes and so forth. The ancient cases aren't so much talking about that. They talk about, first and foremost, the sacred rights of property. They talk about security. They talk about various concerns related to abuse of power. Entic is like that, as is the Wilkes case. They're both basic, they both raise press freedom issues. So, what's important in a lot of ways, you could say, well, a consequence of protection against seizures is that you get privacy in the modern sense of that word. But in the first instance, that isn't really what was being talked about. What was talked about was these basic rights of personal security and basic rights of property that were protected there, and abuse of power by government officials. And from that, we think that if you look at the structure of the Fourth Amendment and what it does, it is in some important way about justification. Warrants are about justification. Reasonableness is about justification. So what is the class of cases in which government officials are put to some special justificatory burden by the Fourth Amendment? And we would say that is situations where they're doing something that is otherwise breaking the law. A second point has to do with, I think Professor Epps talked about this before, the remedial structure. There was no, the modern 1983 action and Bivens actions and so forth didn't exist. I don't think really was contemplated at the time. The way search and seizure protection was historically provided was through trespass or other kinds of tort suits in which a government official would raise their government position as a defense to raise an immunity, and then as a kind of surrebuttal, this kind of claim would be made. So just in terms of how it would have operated, it would have been keyed to the actual law that was on the ground, again, consistent with this theme of legality, abuse of power, and so forth. Concerns about general warrants are again about exempting on a broad basis, exempting government officials from otherwise applicable general principles of private law. The Fourth Amendment is subject to, like the rest of the basic Bill of Rights, a state action requirement. Why is that? Why only make this if you care about privacy? Why isn't why is this only applicable to government officials? And I think that again plugs in with this basic thematic concern. Lastly, the Fourth Amendment, of course, was only applicable originally to the federal government and would have applied against a backdrop of state, or at least primarily state law created, or state law incorporating private law rights, and that was the that is the essential backdrop against which it operates. I guess lastly, I would say it is hard to imagine protestations of a similar sort against government action that is otherwise lawful for a private person to do, and I'm not aware of any such protestations, any concern about such activities in the historical record. That's what the kinds of activities that were at issue here were things that ordinary citizens were not empowered to do. So that's the basic case that we would lay out from the historical record on that. I should also say, as far as the originalism question goes, there are other questions besides what you might think of as the Katz question. They're out there. What about what is the role of warrants, the exclusionary rule, incorporation, all these kinds of questions as well. But it's very understandable to focus on the Katz problem.
Wonderful, everyone. So we have about 15 or plus minutes before I want to open it to audience questions. The audience can type in questions as I understand it, and I'll be able to see them and pass a couple along. Before we do that, I thought we could do one more round of maybe people talking, maybe in a different order if someone really wants to raise their hand and kind of jump the queue a little bit. But what I'd like to focus on now is, in light of these comments we've been hearing about what's the best reading or the best translation or the best originals, there's a lot of statements of degree being tossed around. If people would like to say, what is the specific thing that makes their version of this legally better than the alternatives that I think are on the table? In other words, I think there's at least 3 quite different flavors of this analysis before us, and so you can say, what is it that makes your view the best? Is it you have that one piece of historical evidence, you have that one piece of text, or maybe something totally different from that? Does anyone want to jump in first and take a bite at that? Orin.
Yeah, let me maybe I'll address this by needling my co-panelist in a friendly way, which is, if I just on the focus of whether this is what is the originalist answer, because I gather here in the originalism seminar we're really focused on what is the best originalist answer. And I think Dan and Danielle, your take was that you said it's not an originalist theory, but it has sort of parts that an originalist could use. And when I hear that, I think Justice Gorsuch perhaps is an originalist. But so if it's not originalist theory, then the question is ultimately what's the best originalist theory? It's an interesting theory and interesting language, but is it really what we're driving at? And James, on your proposal, I think the way you put it was it's consistent with certain themes of the original meaning. It's sort of a thematically consistent at a high level. But, we can always play a level of generality game and abstract any actual history into some broad principle and then come back down to some concrete proposal and claim thematic consistency. I think what's different between the two, my co-panelists' ideas and what I'm trying to do is I'm trying to say, I think we actually have an actual understanding of what the public was mostly thinking about, or what the public would have mostly been thinking about. What's a reasonably informed member of the public, what do they think the Fourth Amendment is doing? It's banning general warrants to deal with cases of physical invasion into homes, to take away property. And then that's the core of it. And then we're really focused on what, if anything, beyond that is also covered. And that leads us to kind of into the theory of translation question of do you just say that scenario and nothing more than that scenario? Do you say that scenario and modern day equivalents of that scenario? Do you say that scenario plus, well, here's a theory which can get us to other results? You know, sort of that's, I think, where we're really, I think, disagreeing is what beyond the fact pattern that the public was thinking about should also be included. And it seems to me the answer to that is, I think maybe all of us are trying to come up with some technological equivalent, sort of modern day updating of the Fourth Amendment. And maybe we're just disagreeing on the right way to phrase it, or right terminological tools to use for it. I mean, I think, James, your proposal really is quite different, and leads to, you know, results which I think are pretty far removed from what the text and the history are about. But I think at least with Dan and Danielle, maybe we're kind of on the same page, roughly.
Okay, Danielle or Dan, do you want to jump in?
Yeah, I'll lower my hand. So just one thing, Orin, you know, I said, you know, this is not like an originalist theory in the sense that we don't go through the work to claim this is the original meaning, but we're not disavowing the possibility that an originalist might end up liking the theory. I do think one thing that I didn't really get into in the opening remarks that I think is, I find, and hopefully others do, attractive about our theory is I think it puts the right questions in the right place conceptually. One thing that is interesting about both of the approaches offered by my opposing or competing co-panelists is all the action happens conceptually pretty much at the, is it a search question, right? That's where the Katz test works. And I think, James, your positive law theory also puts the action there. I think as a matter of thinking about how these things worked historically, that does seem odd to me that if you would go in and sort of file a tort suit, the question there wouldn't really be, well, was this, definitionally, was this a search? The question would be, look, was this your house? And then was this your property? Did this property belong to you? Did you have a property interest in that? And we have a whole suite of property concepts that would ask that question. Is this something in which you have an interest? And then is this the kind of thing that would be considered, you know, kind of under common law, an intrusion on that? And so we treat the kind of search seizure question as kind of broad and open-ended, and we put most of the action as having happening at the kind of question of, is this your person, house, paper, effects, and is this an unreasonable intrusion on that thing in which you have some kind of property or private law interest? But I will say just one other thing about our approach is that, you know, I think, as Orin said, and I don't really disagree with him, that there is going to be a lot of overlap between what we're doing and the Katz test and what he wants to do, although we can point to some examples where I think they might lead to different results, at least as applied by courts.
Can I chime in just quickly on that and say, like, when I think about what we're doing is a bit different from Katz, it's in some way I like that we're picking up words that have had like a mostly fixed meaning for a long time. So like trespass and nuisance, and thinking about what search means along those lines. So I always worry when we say like reasonable expectation and then also privacy, particularly that like norms could change really quickly over time. And so it's hard to like fill those with any sort of fixed meaning, no matter how hard we try. And we can acknowledge that the common law ideas of what is nuisance and trespass also change over time. Like there are some like wacky rules that we might no longer hold true. But it feels like they're slightly more like fixed in their meaning and maybe rooted a little more deeply, even if in fact they tend to overlap with the same kinds of analysis that you would do.
James?
You asked what is the singular appeal of the theory. I don't know how to say this right. I'm inclined to say because it's true, because it is right. It's true today, and it was true then. That just in general, it just isn't. By and large, just isn't the case that government officials are differently restricted than private ones. That's kind of fundamentally there. To the suggestion that the results don't come out differently, or I guess for my theory they do. I think they don't come out so dramatically differently necessarily. But that's often going to be true of competing plausible theories, that they're not going to remake the entire universe. There'll be changes at the edges. I don't want to oversell the point that it's a clearer approach, because everything has its ambiguities, but that is something that's in play there. With respect to the levels of generality problem, that is pervasive in this context, where we have, to some substantial extent, really one kind of major paradigm to work from, and we have to figure out how far that goes. I see privacy as sort of extracting a principle of privacy protection from the guarantee against unreasonable searches of persons, papers, houses, papers, and effects, as maybe the kind of ne plus ultra of that. But there are different ways in which this could be done. So if you think about a case like Kilo involving the thermal imaging camera pointed at a house, that strikes me as analogous, at least arguably analogous, to an ancient search in which you're actually inside the house in a way that's kind of more on point than the I think rather airy language of invading a reasonable expectation of privacy would suggest, because there is a sense in which it is sort of kind of going inside and looking inside a house, rather than violating a sense of privacy that a reasonable person would have in the abstract, which untethered from a particular location or a particular means of obtaining information from that location. So the exercise of drawing analogies to the past can be more precise than that. Katz, the other thing that should be said is Katz, by its terms, it makes no pretense of being in the slightest bit originalist or Harlan's concurrence. There's no historical engagement there. It's a great example of a kind of common law whatever of the mid-late 20th century in the style that was then in vogue. And to my mind, what the Supreme Court there basically did was reinvent its own version of Prosser's intrusion upon seclusion tort of roughly the same vintage, but for its own special version of it applicable to government officials. And that's just what they were doing. Maybe you can retrofit an originalist justification for it by casting things at the highest level of generality. I don't know what it means to try and assure that level of privacy today, which would have existed in 1789 or at any other point along the way. I think that's a very difficult thing to do, it couched at that level of generality.
Great. So I saw Orin had a hand up. We're starting to get some great questions. So what I'm going to do is read the first question or version of it, and then maybe hand it over to Orin, because you want to speak on something I think that James was talking about, I gather. So the question is to all the panelists: what, if any, recent Supreme Court decision would come out differently under your approach? And I'd invite you to pick a kind of a signature case that I guess that you would say comes out differently. And one example the questioner gave was Carpenter, but I imagine that some of you may not choose that one for various reasons. Orin, please.
Yeah, so I think I wanted to pick up on what James was talking about of the Katz era being the sort of free-form constitutional interpretation without any first principles. I don't think that's right. I think Katz's problem was that Roe versus Wade was decided 7 years later, in which the Supreme Court uses privacy in a totally different way, and now the sort of 80s era Reagan appointees look back on Katz and see sort of, oh, decision in the past that used the word privacy, bad. The Supreme Court had been using privacy to talk about the Fourth Amendment going back to the 19th century. In fact, there was a time in the 1930s, 40s, 50s, they were talking about the Fourth Amendment guarantees a broad right to privacy. Like every term they were talking about the Fourth Amendment that way. There had been a history of cases that had led to the Katz decision that were really about two different issues. One was about what were the spaces protected by the Fourth Amendment, and the second was whether those spaces had to, if you open those spaces to outside observation, did you still have Fourth Amendment protection? And that's all Justice Harlan was doing in his concurring opinion. He was summarizing those cases. In fact, he says, my understanding of the principle that has emerged from our precedents is there's two-part inquiry. The first part, was it protected by a reasonable expectation of privacy? That was just, is it a protected space? And the other was, did a person manifest an expectation of privacy, which just meant, was it open or closed to outside observation? The problem is that years later, you don't know the history that would have existed in 1967, the backdrop of all the case law that had come before, which I think explained what Harlan was doing. That just kind of gets lost. And then later on, people sort of look at that language in the raw and say, well, that could mean anything. It's untethered, as the way James put it. Yeah, if it's untethered, then it has no connect, then it is non-originalist and it can kind of mean anything. But if you tether it based on the history, I think it actually is consistent with all these principles we're talking about. In terms of cases, if I could just bridge over to the question, Richard, you had asked about cases. I think all the cases are really what we're talking about, since in my view, it's all terminology as to how we reach results. You can reach different results. Like in Carpenter, the originalist justices seem to go different ways, right? Justice Thomas says that there's no Fourth Amendment rights in historical cell site records because it's not their records, it's the phone company's records. Justice Gorsuch, although he doesn't take a position on this, seems to suggest he would craft an argument for why there is a Fourth Amendment protection in that. So that could kind of go either way. But I think the cases are broadly consistent with the understanding of Katz that I've laid out, maybe with one exception, Illinois versus Caballos, the dog sniff case, where probably the court should have said it was not a search because there was no invasion or equivalent invasion into a protected private space. But you could also have reached that result in, this is the same principles apply. You could just say, well, the dog sniff is akin to breaking into the trunk of the car because the dog has such an extraordinary sense of smell. So you could reach that same result in that case too. So I think you can kind of get there in all of these different terminologies.
Okay. Does anyone want to talk about maybe the indeterminacy of the Kerr proposal, or the answer to the question? Dan or Danielle?
I could answer the question. So the first part is not a ton of cases I think would be radically changed under our approach, and that's because there is some overlap. I noticed the question mentioned Jardines. That's the case about the dog sniff on the curtilage of the home at the front door, and Justice Kagan has a great concurring opinion that we rely a lot there, which says, look, these two approaches, the majority takes kind of like a property-ish approach, looks to social customs to try to figure out whether there's an implied license. And the Katz approach, which would look to reasonable expectations of privacy, she says, look, those are basically going to be the same here and in a lot of other contexts. There are some places where we say courts, lower courts and the Supreme Court have maybe gone in a direction just relying on Katz type principles that they might not have reached if they'd looked to a broader set of private law doctrines. One that I liked a lot was some lower court cases about abandonment. When have people who rented a house abandoned the house in terms of the reasonable expectations of privacy such that it can be searched without a warrant? And we talk about the way in which some of those cases are not consistent with property law understandings of abandonment. You still have a property interest if you're a renter, there's certain, Danielle remembers the details, but certain ways in which you still retain a property interest. In terms of Supreme Court cases, I think one might be the aerial overflight cases, California versus Ciriolo, and Orin probably knows how to pronounce that one, and Florida versus Riley, where the court says totally fine as long as they're kind of in, at least if they're in kind of area that's airspace, not clear whether that's determinative, but in airspace that's permissible to fly over. They can look in your backyard, they can look in the curtilage of your home, no problem. I think a lot of people find that result kind of troubling. I don't think we're super definitive, but we sort of said, look, here are some common law principles that you might rely on to get to a different result. Danielle could talk about, the kind of cases we looked at there.
Yeah. So these are actually cases where you have to kind of go deep into what state courts are doing. And so like the land use courts, which are, in some ways, even like a sub-trial court sort of situation. We talk about one like Bigami versus Serrano, where, a neighbor has a joint driveway. One neighbor just puts a camera in the driveway, is recording the other neighbor. And we have Massachusetts Land Court saying, like, look, this kind of persistent recording ends up interfering with use and enjoyment, which we would understand to be a nuisance. So it's impermissible, even though, we have a right to take pictures of and record the world around us, and certainly from our own property. There's something about like the persistence of the recording or continued overflights that does start to interfere with that lower, like tethered to the ground property right. And so these things like are admittedly a little hard to dig up. And there could be a lot of local variation there, which is one reason why we think that a federal court just figuring out if there has been a constitutional violation or any sort of like reference to the federal constitution itself, maybe doesn't want to be tethered to, what is the land use law of this county or municipality in the state, but rather would want to look at what general law principles are.
And just one quick thing, I think we also note in the paper that the next restatement of property is going to have stuff about drones in it. And so that's the kind of thing a court could look at to figure out whether, those things are intrusions or not.
Yeah, the drone industry is very upset about this.
James.
Yeah, a lot of the cases that Dan raised are, maybe sort of similarly, and maybe I was thinking also about Georgia versus Randolph, but what's come up with a lot of these cases, a lot of these involve including Georgia versus Randolph, a case about who can consent to entry. A lot of these cases involve a somewhat separate problem, or at least potentially separate problem, which is these kind of three-party situations, and the extent to which any approach carries over, whether you rely on, say, as in Will's in my model, positive law or reasonable expectations of privacy or something else to try and resolve those is, it's a kind of further question. Likewise, for something like the doctrine of abandonment and all those kinds of things, it's possible that there are different places to get off in different ways in which these basic approaches might be shaped. Just to say one thing, I've been somewhat persuaded, in part from reading Dan and Danielle's piece, that my own reading is much more centered on reasonableness than on the search question, and that's really what's going on, and that where something is otherwise lawful, it's not unreasonable to do. That is to say, what triggers scrutiny, where you have to show that what you've done is reasonable, you have a justification for it, is the fact that it's in contravention of otherwise applicable law. So I think that's probably all I would say about that. And then on the kind of levels of generality, I just don't. I think that's it's just a very difficult question to say. In Katz, well, a phone booth is the equivalent to your home, and taping a microphone to the roof of the phone booth is the equivalent to breaking into your home. It kind of isn't. I mean, it's, it is and it isn't. It is in some ways and not in others, and that's a difficult analogy to draw. On the privacy part, it has seemed to me, going through all this, that there are two uses of the word privacy. The older usage, which is actually in a sense sort of consistent with like Griswold or whatever, is just it corresponds with something like the public-private distinction, stuff that's none of your business. The right to be left alone, as Brandeis put it, which is different from, I think, what I think of as the more prevalent sense today, which is less about that which is, the kind of a sphere of stuff that is beyond regulation or intrusion or whatever, and much more really about informational secrecy or informational, non-disclosure of information. If I say, hey, I want some privacy here, I'm changing my clothes, like that means, don't look at me. It's not about this kind of sphere that is beyond, a free state to intrude upon, but it's much more about, the kind of stuff like under HIPAA, your privacy rights, just information you don't want disseminated. And so there's some possibility for switching there. I'll just say for my own part, it's not that privacy has some overtones of substantive due process that is that sets me off, but just that it doesn't answer the question. It is the answer to the question. Privacy is the result of affording protection against a search. It's not the thing that causes you to have it.
Great. So I want to ask an audience question that I think picks up on something that Danielle mentioned earlier. This is partly directed at, I guess, most directed at you, James. I'm going to peel off to Orin too. So the question is basically, James, whether your approach would leave Fourth Amendment protection up to geography, including local geography, in a way that the alternative approaches would not. And so I guess the invitation is for you to respond to that worry, or maybe we should view it as a positive. And Orin, I think there's a somewhat analogous, a different level of abstraction question for you that I had after your last remarks about what case do you think would be wrong. And it sounded like you were saying the only case you really identified, you thought the reasoning would be different, but even then the outcome could be achieved the same outcome could be achieved just a different way. So I guess there's a different kind of question for you about whether on the approach you propound, is there much guidance to allow for judges to converge on outcomes, or is the convergence just something that's not explained by law, or what is it explained by? So let's start with James, since the audience question was actually pointed most at you.
Yeah, no, I mean, that is an implication that there would be some local variation. That's not unusual in constitutional protection. That's, how the Takings Clause obviously works, and more generally, non-discrimination rules operate in that manner because they take the backdrop of otherwise applicable law, which varies from place to place, and use that to compare, the allegedly discriminatory act. So the First Amendment, which has a strongly anti-discriminatory flavor to it analytically, takes as a background, well, how are you treating others who are similarly situated? I don't think that that's necessarily particularly problematic as an operational matter. For the Fourth Amendment in much of its life is about police officers who are operating within the jurisdiction that they're in. It doesn't strike me as particularly unreasonable to expect them to have an understanding of what the local law is in the jurisdictions in which they operate. And it wouldn't be the worst thing in the world for the feds to have to pay attention to state law to that extent. But it is the case that there would be some degree of variation in terms of what's allowed based on what the rules of the jurisdiction are.
Orin.
Yeah, two thoughts. First, on the issue of local geographic variation, I think it's really important to realize that if you were to tie Fourth Amendment rules to local non-Fourth Amendment standards, what you do is you tell the government, you need to alter your local standards. So whatever your like FBI, you now care about land use restrictions. ACLU, you now need to boost rules, relating to trash pickup or whatever it might be. Sort of everyone's going to start fighting over these areas of law that have nothing to do with the Fourth Amendment as a way of affecting the Fourth Amendment. And that, it strikes me, is really problematic because it could mean we have no privacy at all because the government will, dramatically they'll change these rules at the government's request, or we have, very restrictive rules on law enforcement where we should have more law enforcement power, where the way the lobbying works is the other way. So I think it's really important to have Fourth Amendment standards independently of local rules that have nothing to do with Fourth Amendment. Once you link them, you cause a lot of problems. On the question, Richard, that you had asked about discretion, and I think this is, I think if you want to avoid discretion in Fourth Amendment law on the search question from an originalist standpoint, the simple answer is to just say the Fourth Amendment only applies to physical intrusion, nothing else. All technological surveillance is just not a search. It is not included. You don't have to get into any of that line drawing. You could do that. I think that's bad because the Fourth Amendment then doesn't have much of a role in regulating what it was enacted to regulate. And so once you start embarking on some sort of technological equivalence test, you then invariably end up exercising judgment as to what is a technological equivalent of what. And that, I think, was basically what was going on in Carpenter. Justice Thomas is thinking, well, this isn't like breaking into someone's private space. It's just getting records about where their phone was. Justice Gorsuch, from a little bit more of a civil libertarian direction, is thinking, no, this is tracking someone, that's really invasive. That's like equivalent to breaking into someone's home. And so I think either way, we have these instincts of how to analogize these new technological facts. And unless we are to just, from an original standpoint, just say physical intrusion is it, that's it. Once we embark on technological equivalent thinking, we have to exercise judgment. We have to make these tough calls. And that's what the Supreme Court does. New technology comes along, they tell us where it's classified as search, non-search, in light of its technological role, technological equivalent, and then we move on to the next technology. And that's always going to be hard. But that's I don't think there's a way around that.
Wonderful. That's a great final note to end on. At least it's great for realists among us, I suppose. Thank you, everybody, for doing this. I learned a lot, and I'll look forward to more conversations.
Yes, thank you, Professor Ray, and thank you to all the panelists for joining us. Our next panel will be on the free exercise clause. And to join that panel in about 15 minutes, you should just click on the link for that panel in the introductory email that you were sent. But again, thank you to Professor Ray. Thank you to all the panelists.
Thank you.
Thank you.